As you know, on Friday, January 10th, 2025, the United States Supreme Court will be conferencing no fewer than four Second Amendment cases, including the mission-critical Snope versus Brown case out of Maryland, dealing with the AR-15 semi-automatic rifle ban, and Stephen Halbrook, longtime Second Amendment historian, Supreme Court bar member, and powerful advocate for the right to keep and bear arms, has written a powerful piece explaining why the Supreme Court should take this case. Very important information here, historical information from the man that was involved with not just the U.S. Supreme Court decision in Heller, but Heller, too, a very important case that's going to speak to the issues that the Supreme Court's going to be considering on Friday. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist for our 2025 Gun News Award out there in Las Vegas, the end of January of this month. In the category of top voices of the 2A, top voices of the Second Amendment, we've been a finalist in multiple categories the last several years. Let's see if we can pull out a win with the Gundies for 2025. I appreciate all of your support, and I also appreciate your support, not just for you who follow me over on X, at 4boxesdiner, and subscribe here, and also now subscribing to this channel on Rumble. All right, folks, so here's the story. We know Friday is the big day. The U.S. Supreme Court is going to be conferencing 4 Second Amendment cases: Gray versus Jennings, Snope versus Brown, Ocean State Tactical versus Rhode Island, and of course, Maryland Shall Issue versus Moore, I believe. And in light of that, a friend of the channel, Stephen Halbrook, longtime Second Amendment historian, Second Amendment lawyer, constitutional attorney, member of the U.S. Supreme Court Bar, has written a powerful piece of advocacy for the prestigious Volokh Conspiracy blog. If you don't follow the Volokh Conspiracy blog over there associated with Reason Magazine, you ought to do so. It's very good, especially a lot of geeky Second Amendment and other legal information over on the Volokh Conspiracy blog associated, again, with Reason Magazine online. Check it out if you haven't already done so. Well, Stephen Halbrook has a very powerful piece here arguing why the U.S. Supreme Court should be granting cert in Snope as well as in Ocean State Tactical. Really, with the title of the article, something we've talked about before, whatever happened to long guns good, handguns bad? And that's the title of the article that Professor Halbrook is talking about here. Is, you may recall, prior to the U.S. Supreme Court decision in Heller in 2008, if you go back in time, which I chronicle, by the way, in my book, First They Came for the Gun Owners, where I lay out the history of the anti-gun movement and their strategies. If you go back to before the year of our Lord 2008, when Heller was decided, you will see a very clear strategy by the anti-gun movement in the United States. And that strategy before Heller was that long guns, shotguns, and rifles were good, and handguns were bad. You had organizations like Handgun Control Inc. You had literally efforts to try to ban handguns on the grounds that Americans could always have rifles and shotguns, and they were better for self-defense and the like, and handguns were bad. In fact, what's quite interesting is in the U.S. Supreme Court decision, or I should say in the briefing associated with the U.S. Supreme Court decision in Heller, you literally saw arguments that says that we can ban handguns in D.C. because the Americans living in the District of Columbia have access to long guns such as rifles and shotguns. Stephen Halbrook makes this exact point, summarizing the arguments by D.C. and their amici in the Heller case about long guns good, handguns bad. Fast forward to District of Columbia versus Heller in 2008, in which the District of Columbia's brief argued that its handgun ban does not disarm the district's citizens who may still possess operational rifles and shotguns. The law continues to allow private home possession of shotguns and rifles, which some gun rights proponents contend are actually the weapons of choice for self-defense, or I should say for home defense. Its Amicus Violence Policy Center contended that a wealth of evidence shows that in almost all situations, shotguns and rifles are much more effective in stopping a criminal. Now, I think the reason why Professor Halbrook makes this point is to really show the hypocrisy of the anti-gun movement, right? Because today, in the year of our Lord 2025, what are the anti-gunners saying? They're saying handguns are good, rifles are bad. That AR-15 semi-automatic rifles that in and of themselves have been with us in American life since at least sometime in the mid-1960s in one form or another, right? This is not even new technology if you just look at the AR-15. Never mind repeating weapons like rifles and shotguns and this sort of thing, okay? The point being that it just goes to show you that this is all about banning guns, period, full stop, and they want to do it incrementally. If they could do it all at once, they would do it. They would go full Australian, I have no doubt about it, but they can't, so they're going step by step. They were trying to knock out handguns, but when Heller stopped them, they moved on to rifles, and this is the point that Professor Halbrook is making in this Volokh conspiracy post, where he's essentially arguing that now, all of a sudden, long guns and rifles are bad, which is the totally opposite position that the anti-gun movement and these states and governments have been taken now, that were totally different and opposite of what they were doing before Heller. And what's most interesting about this article is he literally talks about how Justice Scalia carried a rifle on the New York City subway, and how historically, including with the National Firearms Act and the Sullivan Law, it was always, always, always about trying to shut down and stop the possession of handguns. Here's what Professor Halbrook writes. For most of the nation's history, long guns, that's rifles and shotguns, were seen as good, while handguns were depicted by some as bad. The muskets fired at Lexington and Concord became a symbol of American freedom. Restrictions on the carrying of concealed pistols arose in the 19th century. New York's Sullivan Law in 1911 required a permit just to keep a handgun in the home. But as the New York court explained in People v. Rasso in 1958, quote, a rifle may be possessed in the home or carried openly upon the person on the street without violating any law, since in restricting concealed weapons, the legislature carefully avoided including rifles because of the federal constitutional provision and New York civil rights law provision. And Stephen Halbrook goes on to say, I personally heard Justice Antonin Scalia tell how when he was on the high school rifle team, he carried his rifle on the New York City subway. So in light of all this, we know what happened. The big fight was in Heller. In a 5-4 decision, the Supreme Court said that modern firearms cannot be banned no more than you can ban modern methods of communication under the First Amendment. And it goes on to say that if a weapon is in common use by Americans for lawful purposes, you undeniably cannot ban it. And because handguns, for whatever the reason, are in common use by Americans for lawful purposes, the District of Columbia could not ban them. So now, in light of that, where are we now? Well, Stephen Halbrook in this article goes on, actually talks a little bit of history because he was there. He was in the Heller case. He was involved with what's known as the Heller 2 case. And what is the Heller 2 case? Well, what happened was, after the Supreme Court said that you could not ban handguns, what does the District of Columbia do? Well, you know what they do. They do what they always do, these anti-gun jurisdictions. They try to get around Supreme Court precedent, and what do? So what D.C. did is they did not ban handguns because they could no longer do so under Heller, so they went out and tried to ban, shotguns and rifles and the like. And that gave rise to another lawsuit claiming that, the banning of shotgun or the banning of rifles in D.C. was unconstitutional under the Second Amendment. And unfortunately, in a 2-1 decision, and this is very important, folks, listen carefully, in a 2-1 decision in what's known as the Heller 2 case, the D.C. Court of Appeals, a very influential court, in a 2-1 decision with 2 judges saying that the law was constitutional under the Second Amendment, and a dissenting judge by the name of Judge Brett Kavanaugh, who said that obviously this ban on rifles is unconstitutional because these rifles are ubiquitous. These rifles are commonly owned by Americans for lawful purposes, and under the Heller standard, they cannot be banned. Unfortunately, the 2-1 decision in favor of banning guns became the law of the land because all the other anti-gun blue jurisdictions in New York and New Jersey and California and so on embraced the majority opinion in Heller 2, ignoring now Justice, but then Judge Brett Kavanaugh's dissent, and essentially used tiers of scrutiny and various other methodologies to allow these bans in these anti-gun jurisdictions. But again, now in the year of our Lord 2025, the silver lining of that Heller 2 case was the dissent by Judge Brett Kavanaugh, who is now Justice Brett Kavanaugh. And this was a big deal because when you had the Kavanaugh hearings, I was on Fox News repeatedly discussing the Heller 2 case and Brett Kavanaugh and the importance of getting him on the court. And now he's on the court and has done a good job. And I'm confident he will continue to do a good job. But here's what Professor Halbrook has to say about the importance of Justice and then Judge Brett Kavanaugh's dissent in that Heller 2 case. The silver lining in the cloud was then Judge Brett Kavanaugh's dissenting opinion, which is a blueprint for how the Supreme Court should analyze similar rifle bans. The opinion brilliantly exposits Heller's analytic method of text and history, as well as traces the over a century history in which semi-automatic rifles with detachable magazines have been accepted by and are in common use by the American public. Judge Kavanaugh anticipated what the Supreme Court emphatically later held so clearly in Bruin, that the correct method begins and ends with the text and the history. And as Justice Thomas put it, intermediate scrutiny is one step too many. Now, it's also interesting that Professor Halbrook makes a point that we've talked about before. He specifically says there are no circuit splits because the jurisdictions that enact these anti-gun laws are in the same blue state jurisdictions that give rise, in many instances, if not most, to blue state judges. So you've got New York judges, blessed by Chuck Schumer in the Senate, are lording over and making decisions about New York's gun control laws with the obvious outcome. And you simply never have a situation where, like, the U.S. Court of Appeals for the Fifth Circuit down in Louisiana and Texas has a chance to sit on and resolve a assault weapon ban case or an AR-15 ban case, because there are no gun bans in Texas and Louisiana to knock out. Same with the 11th Circuit Court of Appeals down there in Florida and Georgia. There are no, AR-15 bans in those states, so there's no chance for the courts to knock them out because they never get a chance to address them. And that's a good thing, because we don't want courts to have to address our right to keep and bear arms. We really want to nip it in the bud and never have the laws enacted in the first place. Nevertheless, that is a point also Professor Halbrook makes. And then he goes on and makes a final point about the Ocean State tactical case dealing with these magazines. And he really makes fun of the court in the Ocean State tactical case with an observation they were making. I think you'll find this amusing, unfortunately in a kind of a pathetic anti-gun way. But here's what Professor Halbrook has to say. The Ocean State Tactical Court decided that no evidence exists that magazines holding over 10 rounds are used in self-defense, and thus that banning them imposes no meaningful burden on the right to self-defense. It wrote off what the people actually choose with a half joke. The court says, quote, "True, one could imagine Hollywood-inspired scenarios in which a homeowner would need to fend off a platoon of well-armed assailants without having to swap out magazines." Close quote. Well, that's very cute that the Ocean State Tactical Court made that joke. Of course, probably never saw the footage of Kyle Rittenhouse and the mob that was around him. Obviously, didn't see the Korean rooftop and dealing with the people that were coming and threatening to burn down that part of Los Angeles. And, of course, as Joseph Story, the youngest Supreme Court justice, I believe in American history, said that the right to keep and bear arms is the palladium of the republic because it allows us to stop tyranny. And if tyranny ever arises, it allows us to fight back successfully. So all these things were obviously lost on those Rhode Island courts in the Ocean State tactical case. But hopefully the U.S. Supreme Court, looks to deal with this, dealing with magazines holding more than 10 rounds. Although, in my estimation, I think we're far more likely to get a grant of cert in the Snope case dealing with semi-automatic rifles than we are in the Ocean State Tactical case, because the Ocean State Tactical case is up on a preliminary injunction procedural posture, while the Snope case is up on a final judgment. And I think the AR-15 case is a cleaner case in all respects than the magazine, not because it's cleaner from my perspective or your perspective, but from the U.S. Supreme Court's perspective. I think they're more likely to take a straightforward rifle ban case than a magazine case right now. So there you have it, folks. A good summary of Stephen Halbrook's view of what's going to go on Friday. He does also make reference, of course, to the Maryland Shall Issue versus Moore case and the Gray versus Jennings case, makes a couple observations there. I'll put a link to it down below to the Vola conspiracy piece by Professor Halbrook, and you can take a look at it for yourself. But again, Friday's a big day. Let's keep our fingers crossed. Let's keep the candles lit, and let's hope for the best, because this is a big deal, folks. We really need some good news here. I think it's very important for the Second Amendment movement. I'm not saying we will be totally SOL if we don't get a cert grant on one of these cases this week or in the next couple weeks, I should say. But it will not be good, in my opinion, if we don't get a cert grant. And, I don't know. I don't know which way it's going to go. I'm not on the court, and I don't know exactly what's going to happen, but I got my fingers crossed. All right, there you go. Hope you enjoyed today's episode. Make sure you follow me on X at 4Boxes Diner. Don't forget to like this video and share it and subscribe. We're trying to get to 200,000 subscribers. Thank you again for your support for the 2025 Gun News Award. And again, I look forward to talking to all of you again very, very soon here at the 4Boxes Diner.
Orders up. Table 2A.